Thanks for coming, everybody. So this is the website. Thanks for coming. Hopefully all of you know why you're here. You're going to be an advocate. I've came out with about 8 bills per state, and they're all on the website except for one, parental alienating behaviors. And that one is to return the funds that somebody cost you when there's gatekeeping, false allegations, and interference with child custody in your case. They're going to end up paying both attorneys and all the professionals in your case. So that one's finished. It's just not on the website yet. When you first come to the website, there's a couple of things. This is the homepage. You can go to view bills. You can schedule a call if you want to talk about your case. I'm still writing about 300 more bills, so that takes a lot of time. And you'll see why, because the bills that we're going to talk about today. On here has some of the stuff that I've done, speaking, legislative. So if somebody wants to know anything about the background, it's on there now. Had people asking, and so it's on there. The federal coalition, you won't do anything with. That has to do with President Trump's team and some other stuff. That's for them to get a hold of me. So this is the bill stack. And when you hit view bills, you can see all 8 of them are here. And it says the New Start Equality is one. And you can scroll down. Time taken, time back. 3 strikes law. Justice delayed, justice denied. Cameras in the courtroom. Child support, dual calculation. And the Litigant Access and Economy Act. So a New Start Equality is 50-50. And right now I have it on Iowa. I'll just leave it there. If you want to change the state that you're in, you can click on this and you can hit allow or block, hit save, and it'll change it. But that's how you change whatever state you're in if you want to do a different state. New Start Equality, you can go to view bill. And just so you know, I'll go ahead and talk about this too. So when you go to robertgarza.us, when you hit view bill proposal, it'll show you the bill itself. But where you really want to go is right here at the top. It's view legislator pack. When you click on that, that will give you the 3 things that you need. And if you look, so this is for Texas. Right here, you don't really need this. This is if you're writing a letter. You can copy and paste this whole page, but you add your legislator's last name here and your name. And then literally all you do is just copy this and then right click, hit copy, paste it in an email, and then send it to your House rep. Go to Google, type in who is my senator, who is my House rep, and put in your address, and it'll find it very quickly, and it'll tell you who they are. It'll give you their address, it'll give you their phone number, it'll give you their email address, and then that's who you send it to. Once you send this, this tells a little bit about the bill, that you're asking for Equal Shared Parenting Act, and both parents have to be fit, willing, and able and live within 25 miles of the child's school. It's that simple. If you look, this is also asking for a 15 to 30 minute Zoom call. And then once you do that, hopefully you'll get it. You can attach this, which is a background and a need for the bill. And it just goes through a little bit about shared parenting and why children need it and what's good for them. The bottom part is the bill itself. Now, this is amended for your state. Right now, this is on Texas. If you put Ohio, it's going to say Ohio. If you put New York, it's going to say New York or anything like that. And all these codes are for your state. And when you come in here, I made this very, very simple. So in this bill, it's only 1 page long. And the meat of it is both parents have to be fit, willing, and able and live within 25 miles of the child's primary school or education institution. Now, the other thing I did was this presumption may be rebutted only by clear and convincing evidence in writing. Now, that's huge for this because right now in family court, it's a preponderance of evidence. This tells it has to be clear and convincing. And then if there is a history, and I had to put this in here too, which if you look is probably the longest part. There's 4 sections to this versus 2, which parents had to be. This is what the parents should not be. And so history of violence, child abuse, sexual abuse, substance abuse, someone that's refusing to co-parent, and limited access in distance. So if you live like 200 miles away, you shouldn't be getting 50-50 because to drive the child to school every day is it's impossible. So that's why that is. And then just goes into that provided that each parent receive at least 45% of annual overnights. And then if the judge wants to go against the 50-50, they have to put in writing by the court, not another attorney, that equal parenting time would not be in the best interest and include, but not limited to, and all this other stuff. They actually have to tell you why you didn't get 50-50. So they don't do that right now. Basically, we're just starting a new start equality. And if you already have a 50-50 bill that someone's already submitted into your legislature at the same time you do, it's okay because both bills are going to be heard. And if theirs is 23 pages and yours is one, I can almost guarantee you this one will pass. And I keep telling people this, it's like a relay race. You want to just get the 50-50, a new start at equality in there right now, and then worry about everything else. But we want to get those children with their parents that are fit, willing, and able, and no domestic violence and all that other stuff. Once you have that time, all someone has to do is make a false allegation. And this is what the time taken, time back bill is. This one passed in Texas already, went into effect 2023. And then see here it shows in progress and passed. So this one has already passed. And this is what it looks like in Texas. So it shows a court shall order additional periods of possession and access to a child to compensate for a denial of court-ordered possession. In this, we have what's called CPS, and it's Child Protective Services here, and it's the Department of Protective Family Services that did not result in a finding of abuse or neglect. Now, I got it across the line, and we're going to amend it again, and you can see in other states why I did this too. I'll just go to a different one real quick here and show you. So if you look in Texas, I got it done, but it was for the Department of Protective and Family Services, because when I went through this 43 times, my ex was able to do this by proxy and hijack my time basically. But this one, I put in all of the rest of them, I put any investigative agency. So that includes the court, that includes the police, that includes the DA, that includes any investigative agency that would investigate you. When that investigation does not result in a finding of abuse or neglect, then you shall be the same type of time and the same amount of time, the duration. So, and then you can choose holidays, stuff like that. And someone had asked this last time, well, what if about a parent if they're gonna graduate? Well, if they're graduating and they hijacked your Christmas, next year they're gonna be aged out. So you can't do that, but that's in here too. A parent who is denied parenting time shall have the right to designate the times and dates of additional periods of possession and parenting time. So that's even built into this. I've tried to think of everything, and after amending 400 of these, and I kind of see where a loophole is, and I'll shut it down.
Interactive, or is it just going forward?
It's only going forward.
Okay.
Let me explain that too. I can't. So in Texas, I could have retroactive the time taken, time back. I didn't do it, and I would have gotten almost 2.5, 3 years back of my kids. I didn't do it because the legislators had no argument against the bill because it's so strong. When you return that child, you shall return the time, the same type of time, and it's to repair that parental bond that was broken by precaution by the court. But when you're stopping up the courts, that's when you have an issue. And if I would have done it retroactive, everybody would have came and got it back. Now, would I want my time back? Absolutely 100%. But I gave up my own children's time with this just to make sure that it would have gotten through and nobody else would have to go through what we went through. So I understand, but at some point you have to be selfless. And if you're not, then you don't really belong in this group, because all this is for, if you have children in court right now, it will eventually help them, but this is going to stop all of what you went through and everybody before you. And so I believe so passionately about these bills. I didn't name them after me, my children, or even ask for my time back. And I hope that everybody has the same sentiment. I think showing that to senators and House reps, they knew I was serious about the bill, that I was passionate about the bill enough to sacrifice that my own time with my kids so it would go through. And I really didn't want to hurt the court. I wanted it to work cleaner, fairer, and discourage the false allegation. So that's time taken, time back. Now, when I came out with my law, my time taken, time back, and my ex couldn't make false allegations, she started interfering with my child custody. I called the cops, they came out, said it's a civil matter, except I knew it was a criminal matter. So I educated myself on it, told them that I know what the process is, and you have to take a police report, then it goes to a detective in the youth division, they find probable cause, then a DA, and then a grand jury. That took me 6 months to get. I also, at the same time, for the same offense, did it in family court. It took 6 months to get into family court. And then after we had the hearing, it took 6 months after for the judge to rule. A year later. That's way too long. So I came up with the three strikes, and three strikes is very pretty. Again, when you click on it, go to view legislator pack. Again, all of these are set up the same on every one of these. So just copy paste into your email, just copy this and then paste it in your email, and it tells them that it's a first offense is $500 fine, second fine, and then the third time it's a felony. And gives a little bit of background about the bill. Then it has the bill already amended for every state. This is for Ohio. The other thing, when you look at this, it makes it very simple. So right now, the cops come out, it's a $500 fine, first time, second time, third time felony, but it's taken care of very quick if you think about it this way. So most parents have every first, third, and fifth weekend and Thursday possession, whether it's 2 hours or overnight. The first $500 fine is the first possession that they withhold, which is, let's just say Thursday. That's the first 500. Friday, Saturday, Sunday is the second period of possession. That's the second $500 fine. The third possession period is the following Thursday. That they're going to get arrested if they withhold again. And so this is literally taken care of in a week rather than what I went through right now is a state jail felony the first time. They didn't arrest her or anything. They made the police report. It took 6 months to get to the grand jury. It took 6 months to get to the court, and it took about $3,000 to $5,000 for the attorney to file the enforcement action. All way too much. And so this will literally take care of it in a week. Now, I hope nobody gets a $500 fine or the state jail felony. I hope that the threat of the fine itself is enough to just deter anyone. The next one is justice delayed, justice denied. Now, I told you it took 6 months to get into court and 6 months after we had a hearing for my judge to rule. And so that's way too long. I've already been through this. I've been through 16 years of family court. I know that judges forget, they're human. I use this phrase like, what did you have for lunch last Thursday? You don't know. And that was only 3 meals, for every day. A judge sees 5 to 15 people a day and the same type of people. And because they're all arguing about family, they're not going to completely remember your case unless there's something really weird about it. Even so, you can't wait 6 months on hearing something and then rule on it. That's impossible. That's not justice, and they can't possibly put justice out like that. So I called it justice delayed is justice denied, and it's a 10-day timely rulings in all cases for court. And same thing, this is the letter that you write to your legislator. That's a background about the bill. Now, the cool thing about this is that it gives 10 business days for the judge to rule. Then the other thing I did is that I said of a hearing or trial, which if I would have just put hearing, then they could exclude trial and they had discretion over that. Remember what I'm telling you is that I've been through all of this. And so I know where the loopholes are, and this would have been one of them if I would have left it that. But I'm also giving you 7 business days after the submission. And what that is if you have a hearing and somebody has a drug test, then the court has 7 business days to rule on after they get those drug tests, because those are important too. Now, I still didn't limit the judge's discretion because they still have as much time as they want. But now the judge has to write an explanation every 10 days for the delay. See, that's what they don't have now. They can just put you in legal limbo. So now it holds them accountable, which they're not right now. And then it also, with this 10 days, if they take 30 days to rule, then now you have a case against the judge and you can turn it into the SCJC here in Texas, which you can get them reprimanded for not following the law. But this is not a gray area. It's very black and white after these pass. So right now, they can't get in trouble for not ruling because there is no laws telling them that they have to rule in most states. So if you're having problems with your judge, you're going to want cameras in the courtroom. If this would have helped you, I would say do whichever one of these first. What would have helped you more? And so a lot of people say that their judge was biased and whatever else. Well, if there was cameras in there, the judge probably wouldn't be biased or even put all this stuff on the record. Now, the cool part about cameras in the courtroom, this shall be video and audio recorded. Again, if I just put cameras in the courtroom and didn't put shall be video and audio recorded, that's a gray area. That's where they have discretion. They're like, well, it doesn't say this. This is the problem with family court. This is why all of you are having the issues that you're having. This makes it to where it's very black and white. Then it says the recordings shall include. That's a very strong word. That means it's going to happen. And this says including during recess and off the record exchanges held in open court. So when the judge says, okay, we're off the record, the court reporter stops. She doesn't keep recording. That's when a lot of the stuff happens. And so with cameras in the courtroom, that would have been recorded. And so that's what this does. But it also goes in to saying that it's only the privacy interests of the parties and the witnesses. I've included everything in here to include that it's just for the people and the litigants and their attorneys. That's cameras in the courtroom. And then we have child support dual calculation. Now, if you click on it on your state, it's probably not going to show because this is a real headache because it's not just amending some simple law. This is tied to a bunch of federal stuff too. So I'm still dealing with that. It's doable. It's just taking a while. But what this is going to do, it's going to recalculate child support to take both parents' incomes and their amount of time with the children into consideration rather than just saying, okay, one child's 20%, two child's 25%. Yeah. The Litigant Access and Economy Act, this one was born because a friend of mine is an attorney and he had to charge his client $1,200 for a 2-minute hearing. And so when he went to court, I was like, why didn't you Zoom? And he said, well, it's up to the judge and judge never allows it. So, that's not going to happen. So all this one does is it allows you as a mother or father, let's just say you're at work or stay at home or anything like that, it allows you to Zoom in and the judge has to have in writing if they don't want you to Zoom in. And so it's a big game changer. And the last one, appealable temporary orders. So appealable temporary orders is most of you, your final orders are your temporary orders because most of you run out of money and can't get to final trial. The judge is giving you 20 minutes to hear what kind of parents you are, and usually are throwing mud at each other. So they make a quick decision, and if they get it wrong, or if the judge is one-sided or whatever, you can't appeal anything or gets it totally wrong. You can't appeal anything unless it's a final order. So you can't even take it up to a higher court unless you have that. And so this keeps you in legal limbo forever, especially if you can't keep proceeding with all the other people they put in, which is like home studies, psych evals, whatever. So what this does, it allows you to appeal your temporary orders, which is amazing. Like this would have helped so many people. And if they order a bunch of stuff, if they order these psych evals, these home studies, and you can't pay for them, you'll be able to do something about that now because you can appeal it and show that you're indigent or you're whatever and you can't pay for these things because right now the courts don't really care. So this is a very strong bill. So any one of these that would have helped you, then for sure. And the way it works is once you get these bills and you send your legislator this letter, when you get that Zoom call, go back into our messaging group and put at Robert Garza and say, hey, I set up a 20-minute Zoom call. Guy that just got off the Zoom call, he did that today. I think he put it in Arizona. He said, hey, at Robert Garza, I have a meeting set up. So I said, okay. But if you can't get a hold of me, go to my Facebook page and type in at Robert Garza and put, hey, I have a Zoom call. Please, personal message me, direct message me, whatever, and just get my attention. Believe me, you are not, if you got a meeting set up, absolutely bother me. Blow me up, do whatever you need to do. I will not be mad at all. So if you know anybody, you can send them to my website, robertgarza.us. You can click join the team and then up here, you can donate if you want. There's credit card, Venmo, PayPal, Zelle if you want to donate to us. And, some people just want to donate. They don't want to be advocates. That's fine. Some of them want to be both. Totally up to you. But I can tell you the family court system is a $60 billion and they're not going down without a fight. And I can tell you, I took this as far as I can on a shoestring budget. And if you know a church that wants to help because this has to do with families, then absolutely do it. If you're a grant writer, absolutely. You have my permission. We'll work it out. I don't mind, especially if you're a grant writer or know a different way that this can happen. If all of you want to do time taken, time back, or 3 strikes, or both, then you can all go to your state senator and House rep and educate them on it and say, hey, look, and whoever takes it first and turns it into a bill and gives it a bill number, what happens is now you've educated already, 20 people on it, because if there's 10 of you, you've educated your state senator and your House rep. Now when the bill comes up, they'll be able to understand it because they're like, this is what Dennis was talking about. And so even better. So if there's 4 people that want to submit the same bill in your state, that's fine. You can each go to whoever, but whoever does it first, that's who submits it. And then the other people are just sponsors. You can have as many sponsors on a bill that you want. Even though, let's just say you get time taken, time back, and then there's four other people that want it too because they talk to their senator or house rep, we'll just have them as sponsors. Does that make sense? I try to make it as simple as possible. Literally, just copy paste an email, get a Zoom call with them. When you call them, I'm sorry, when you email them, make sure you follow up with a phone call the next day and say, "Hey, did you get my email? Can you look? Get their name. If you talk to Kim, then say, "Hey, Kim, can you set up a call, a Zoom call with me and the senator?" Or if not, just the staff member. The staff members are amazing. Don't be afraid of the staff members. Don't be hurt that they didn't put you in contact with the senator or the house rep. Usually you're going to talk to a staffer before you talk to the senator or house rep. But once that happens, I guarantee you, we'll seal the deal. Like 90% of the time, we'll seal the deal unless they are like already head set on whatever. Like I talked to one the other day that was a senator and she was already against shared parenting. We kind of flipped her over it. Now she's going to do her own research on it because we opened her eyes. So, and she tried to shut us down. Actually, she did try to shut us down right away, but we were persistent. And then she was like, "Oh wow, like I didn't know this and I didn't know that." And so she wasn't married, she had no kids, so there was no purpose in this for her because it's not going to deal with her. So, but she did tell us who probably would take the bill. So even better. But she said when it came up after she did her research, she probably would vote for the bill. So that's a big plus. So you
Mm.
can educate these people. You just have to have the right information to do it. If you go into the chats, be sure that you go into your own state and talk to people in your own state. If you need help with your case or anything like that, don't go fill up the main chat because people are turning off their notifications, and that's where I go put the Zoom links and on announcements. So if you keep something on, definitely go to the announcements part of the messaging place and make sure that you have that turned on. Also, in announcements, when we get senators that make the bill into, when they give it a bill number, I will put it in the announcements also so you know that that one's taken care of for the state already and y'all don't have to worry about it. And I'll also go into your own states and say it. And then once it turns into a bill number, then they will have hearings on it and then you'll have to testify. And I have a whole thing about testifying. So other than that, that is it. I'm going to hit the recording to stop.